Dear students, I am Mr. Jahan, lecturer, Department of Law, World University of Bangladesh, and this is my class lecture on the topics of control of the administrative power. Failure to exercise discretion. The main object of conferring discretionary power on an administrative authority is that authority itself must exercise the said power. If there is failure to exercise discretion on the part of that authority, the action will be bad. Such type of law may arise in inter alia the following circumstances: sub-delegation, imposing fetter on discretion, acting under dictation, non-application of mind, and power compelled with duty. D. Smith says that a discretionary power must in general be exercised only by the authority to which it has been committed. It is a well-known principle of the law that when a power has been confided to a person in circumstances indicating that the trust is being placed in his individual judgment and discretion, he must exercise that power personally, unless he has been expressly empowered to delegate it to another. The main object of conferring a power on a particular administrative authority is that the power must be exercised by that authority and cannot be sub-delegated to any other authority or official. Delegation may be the result of honest misappropriation by the authority. Concern of the legal position, it sometimes arises out of a desire to expedite official business, but still it will not be invalidated if it is not legally permitted. In Allingham versus the Minister of Agriculture and Fisheries and Ganpati Siaji and the state of Asmeri, the sub-delegation power was held to be bad. Again, where the Act provided that no suit shall be filed for eviction of a tenant without permission of a district magistrate or any officer authorized by him, an order granting permission by additional magistrate to whom the power were delegated was held valid and legal. Proper test whether sub-delegation is legal or not is to decide whether the final decision rests with the authority on whom it is conferred by the Act. If such decision is taken by that authority, the decision is valid. If the decision is taken by any other authority, it would be invalid and unlawful. An authority entrusted with discretionary power must exercise the same after considering individual cases. Instead of doing that, if the authority imposes fetter on its discretion by adopting fixed rule of policy to be applied in all cases coming before it, there is failure to exercise discretion on the part of that authority. What is expected of the authority is that it must consider the fact of each case, apply its mind, decide the same. If any general rule is pronounced which will be applied to all cases, there is no question of considering the fact of an individual case at all and exercising discretion by the authority. By shutting the ear, the authority cannot foreclose decision-making process. In R versus Metropolitan Police Commissioner, a chief constable adopted a rigid rule not to institute any prosecution at all for an antisocial class of criminal offense, and this action was held to be bad. Sometimes an authority entrusted with a power does not exercise that power, but act under the dictation of a superior authority. Here the authority invested with the power purport to act on its own, but in a substance the power is exercised by someone else. The authority concerned does not apply its mind and take action on its own judgment, even though it was not so intended by the statute. In law, this amounts to non-exercise of power by the authority and the action is bad. It is well settled that if the authority permits its decision to be influenced by the dictation of others, it would amount to abdication and surrender of discretion. If the authority hands over its discretion to another body, it acts ultra vires. In Orient Paper Mills versus the Union of India, under the relevant statute, the deputy superintendent was empowered to levy exercise. Instead of deciding it independently, the deputy superintendent ordered levy to exercise in accordance with the direction issued by the collector. The Supreme Court set aside the order passed by the deputy superintendent. There is another case, Barium Chemical Limited versus the Company Law Board. Investigation of the affairs was ordered by the chairman. This action was challenged inter alia on the ground that it was taken on the behest of finance minister. Holding order legal valid, the court observed that the circumstances might create suspicion, but suspicion, however grave, cannot take the place of proof. When a discretionary power is conferred on an authority, the said authority must exercise that power after applying its mind to the fact and circumstances of the case in hand. If this condition is not satisfied, there is clear non-application of mind on the part of the authority concerned. The authority might be acting mechanically without due care, caution, without sense of responsibility in the exercise of its discretion. Here also, there is a failure to exercise discretion and the action is bad. In the well-known case of Barium Chemical Limited versus the Company Law Board, an order of investigation against the petitioner company was passed by the central government. Under the Companies Act, the government was empowered to issue such order if there are circumstances suggesting fraud on part of the management. So it was held by the Supreme Court that it was necessary for the central government to state the circumstances which lead to the impugned action so that the same could be examined by the court. Several statutes confer powers on administrative authorities and officers to be exercised by them in their discretion. The power is permissive language such as it may be lawful, it shall be lawful, it may be permissible, etc. So the question is whether it is open to the authorities to exercise or not to exercise the power to their sweet wills. It has been said that in certain circumstances the word may should be read as must, but it is clearly wrong. In Baker v. Cotton, Lord Justice rightly stated that I think that great misconception is caused by saying that in some cases may means must. It never means must as long as the English language retains its meaning, but it gives a power. And then it may be questioned in that cases where a judge has a power to give to him the word may, it's become his duty to exercise it.